The back door to the victim's residence was a focus point in the investigation. DeShon's DNA was found to be within a mixture of DNA found on the inside doorknob. Being as though DeShon had briefly lived at the residence, the DNA sample did not stand out above the others. There are different versions and reports in regards to the manner condition of the back door on the morning of January 27, 2011. According to the CAD report, on January 27, 2011, at 10:19 a.m., a call was received from a mother explaining that she returned home, finding her 17-year-old son and 19-year-old daughter dead. Also noted by dispatch, caller believes someone unknown 21 the house because the back door has been kicked in. Leon County Sheriff's Deputy J. Van was first at the scene. Deputy Van reported that on the morning of January 27, 2011, Van, found the back door standing open around 6 inches. In this report, Leon County Sheriff's Detective Pearson stated, "I observed Deputy Van and Sergeant Green enter the rear of the residence through the back door. As I entered the back door to the residence, Sergeant Green informed me that the residence was clear inside. I walked through the kitchen and into the living room." Here in Sergeant Pearson's report, Deputy Van determined that the back door to the residence was found halfway open. Deputy Van stated that this was the entry point deputies used to enter the residence, to make sure that both parties were deceased and to make sure that no one else was inside the residence. In the summary of offense and probable cause charging DeShon Thomas with 2 counts of first-degree murder, it was stated by Leon County Sheriff Detective Don Odham that DeShon's AT&T cell phone records were pinging off a tower in the location of the victim's residence. DeShon Thomas sat in the Leon County Jail for over 2 years before he had been provided with any information in regards to his cell phone records. In this memorandum from Darren Shippey dated September 4, 2013, Assistant Regional Counsel Darren Shippey informed DeShon of what Ms. Rayburn, who works with the Leon County Sheriff's Department primarily in the capacity of providing criminal analyst support, such as with cell phone records, was able to provide. Assistant Regional Counsel Darren Shippey states to DeShon in the memo, "She, Ms. Rayburn, reviewed the cell phone records in your case and was the person who, with that information, determined that cell tower, cell number, DeShon's cell phone number, was using a relevant time on January 26, 2011 and January 27, 2011. She, Ms. Rayburn, explained the manner in which she reached her conclusion, which appears to be supported by the written documentation that I have received through discovery with respect to cell phones. Although she, Ms. Rayburn, did not receive from the phone company the content of 2 text messages sent from and received by DeShon's cell phone number at 4:14 and 4:15, she does say the records show that a text was sent from that phone at 4:14 a.m. to Ross's phone at 4:15 a.m. using a cellular tower near 234 Bluntstown Highway. My research reflects that the cell tower site used by DeShon's cell phone number is a little more than 3/4 of a mile from 1740 Corwood Circle, about 8/10 of a mile. This is a copy of Leon County Sheriff Leslie Raybon's cell phone records for DeShon's cell phone. This is not AT&T's document. Leon County Sheriff Criminal Analyst Leslie Raybon presented this as how she was able to locate cellular tower for DeShon's cell phone. This is not AT&T's document. Trenton Ross's cell phone records were not presented to support Ms. Raybon's accounts. 17-year-old Sterling Connor Jr. and his pregnant sister, 20-year-old Laqecia Herring, deserve to have their murders investigated as thorough as possible. On the morning of January 27, 2011, and part of securing the crime scene, Deputy Van started an entry control. According to the entry control, no one from the District 2 Medical Examiner's office ever arrived at the crime scene. In the summary of offense and probable cause charging DeShon Thomas with 2 counts of first-degree murder, it was stated by Leon County Sheriff's Detective Don Odham that DeShon's AT&T cell phone records were pinging off a tower in the location of the victim's residence at 4:14 a.m. and 4:15 a.m. Deputy Cliff Couch obtained DeShon's timesheet from work showing that DeShon Thomas clocked out at 1:30 a.m. on the morning of Thursday, January 27, 2011. The last known outgoing activity from Laqecia's cell phone was on January 26, 2011. DeShon sat in the Leon County Jail for over 2 years before he had been provided with any information in regards to Sterling Connor Jr. and Laqecia Herring's autopsy reports. In this memorandum from Darren Shippey, dated September 4, 2013, Assistant Regional Counsel Darren Shippey informs DeShon of what District 2 Medical Examiner Dr. Anthony Clark was able to determine using notes and pictures taken by Leon County Sheriff's Crime Scene Unit on the morning of January 27, 2011. Assistant Regional Counsel Darren Shippey states to DeShon in the memo Dr. Clark had reviewed his autopsy reports for both Ms. Herring and Ms. Connor, as well as crime scene photos. After considering everything that was available to him, his best estimate, and no one can give an exact time of death, is that death occurred about 24 hours prior to his contact with the bodies, plus or minus several hours. Generally speaking, that could place the time of death in the early morning hours of January 27th. In the following audio clip, Dr. Clark is providing testimony in DeShon's trial on October 16, 2013. In the clip, Dr. Clark states both victims as being in the same state of rigor mortis. Please listen.
Are you able to tell us the time of death with respect to either Laqecia Herring or Sterling Connor?
I believe, and let me just check on hers right quick, that the rigor mortis was already starting to deteriorate, so that when we look at the stiffening of the body, the first 12 hours the rigor mortis forms, the next 12 hours it stays firm, and in the next 12 hours it starts to break down. So in my mind, slight to moderate means that it's starting in that about 24-hour phase, starting to break down. Now that is based on a room temperature, normally dressed for that time. Now if somebody is exposed to high heat or humidity or direct sunlight, it may accelerate the process. The livor mortis, which is the settling of the blood, was fixed, I believe, on both of them. Let me just check my notes real quick. Yes, the livor mortis was fixed in both of them.
Here, let's go back. Prior to signing the contract for service, Gregory Cummings promised to produce a copy of the victim's autopsy report to DeShon and I. As of July 16, 2012, over a year and a half after having signed the contract for service, Gregory Cummings had not produced a copy of the victim's autopsy reports. Neither had Gregory Cummings discussed with DeShon any information in regards to the deaths of. On January 16, 2012, Gregory Cummings emailed me 7 pages from Sterling Connor Jr.'s autopsy report. In Laqecia Herring's autopsy report, Dr. Anthony Clark notes in part post-mortem changes as rigor mortis is slight to moderate. In Sterling Connor Jr.'s autopsy report, Dr. Clark notes in part post-mortem changes as rigor mortis is moderate to full. Dr. Clark's autopsy report stating Laqecia Herring rigor mortis is slight to moderate and Sterling Connor Jr.'s rigor mortis is moderate to full does not put Laqecia Herring and Sterling Connor Jr. at the same stage of rigor mortis. This Internal Affairs Master Log for the year 2012 shows that on September 1, 2011, Sheriff Campbell reported Clifton Couch for an unknown reason. Clifton Couch left the Leon County Sheriff's Office. Deputy Clifton Couch worked on the Deppel murder case under lead detective Melinda McBride. Deputy Clifton Couch reported that during the evening hours of January 27, 2011, Sergeant Gainey directed him to respond to the Wolf Creek subdivision to get a statement from a possible witness. The witness advised that she'd seen a suspicious person at the victim's residence on the night of January 26, 2011, the night before the victims were found murdered. Sometime between 2100 and 2300 hours, she said that the person must have moved to the door very quietly because she didn't hear him approaching. She said that he had his hands in front of him as if he was possibly concealing something. This subpoena dated July 2, 2013, prepared by Assistant Regional Counsel Darren Shippey, is for a pretrial hearing and is addressed to Detective Velveeta Couch with the Leon County Sheriff's Office. This subpoena was filed with the Leon County Clerk of Court on July 17, 2013, and was received by someone at the Leon County Sheriff's Office. If there is a Detective Velveeta Couch with the Leon County Sheriff's Office, he or she did not work on DeShon's case. No other attempts are on record as to Assistant Regional Counsel Darren Shippey making any effort to reach out to former Leon County Sheriff's Deputy Clifton Couch. Naturally, this seems like an attempt to prevent Clifton Couch from providing possible favorable testimony in DeShon's case. During DeShon's trial, WCTV reporter Julie Montanaro reported on October 17, 2013, most, if not all, of the eyewitnesses' testimony, which was close to what the eyewitness had told Clifton Couch nearly 3 years earlier. State Prosecutor Jack Campbell asked Julie Montanaro to conceal the identity of his key witnesses. However, Julie Montanaro exploited the witness for DeShon's defense. The young female college student, who was a neighbor of the victims at the time of their murders, had her name published on WCTV's website prior to the jury receiving the case, possibly putting the young woman's life in the real murderer's crosshairs and sending the message to others in the community, especially to the young people, that if you testify against the state of Florida, particularly any of State Attorney Willie Meggs' assistant prosecutors, then you will be exploited. Here, Crime Scene Unit Detective F. Smelt reports the victim's residence was searched by violent crimes detectives. The report further states Detective D. Odham located and seized a cell phone between the head of the bed and the west wall in bedroom number 2. Here, First Lead Detective McBride reports, during the search, Detective D. Odham located Herring's cellular phone upstairs in her bedroom, located between the wall and her mattress box spring. See Detective Odham's, Detective Pearson's, and Crime Scene Detectives reports also. This Leon County Sheriff's Office CIB Supplemental Continuation Agency Report number 11-18445 states officer reporting is Detective D. Odham. Under additional information and part states, on Thursday, January 27, 2011, I responded to 1740 Coreywood Circle as part of the Violent Crimes Unit. It further states, after a search warrant of the residence was served, I assisted other detectives on the scene with the search. During the search, I discovered a cell phone between the mattress and the wall of the female's bedroom. The phone was placed into evidence. This property receipt shows cellular phone seized by Detective D. Odham. In this Leon County Sheriff's Office offense incident report signed by Leon County Sheriff's Detective Brian Pearson, Detective Brian Pearson states, I searched the upstairs southwest bedroom. This bedroom is believed to belong to Sterling. Several miscellaneous items, papers, rap lyrics identified this room as Sterling's. On the top shelf in the bedroom closet, I located a package containing numerous small individual jewelry bags commonly used to package narcotics inside. These items were photographed and collected by Detective Fred Smelt. I was unable to observe any other items of interest or that could possibly be related to the homicide. Detective Brian Pearson's report further states Detective Don Odham called out to this detective and advised that he had located a cell phone in the southeastern bedroom. This bedroom is believed to belong to Laqecia Herring. Detective Odham was able to determine that the cell phone belonged to Laqecia. Detective Odham seized the phone as evidence and brought it back to the Leon County Sheriff's Office. Despite there being a long paper trail of reports showing that during the search of the victim's residence, Detective Don Odham located and seized Laqecia's cell phone. During DeShon's trial on October 16, 2013, Leon County Sheriff Detective Brian Pearson committed perjury when he testified opposite of his and other detectives' reports. Detective Brian Pearson's trial testimony is an attempt to cover up for the unlawful acts of Leon County Sheriff Larry Campbell and 2nd Judicial State Attorney Willie Meggs, along with some of his assistant state attorneys, including Jack Campbell. Please listen to this audio clip of Leon County Sheriff's Detective Brian Pearson's trial testimony. Please listen.
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? I do. All right, thank you, sir. If you make sure you answer in the microphone so we can all hear your responses. Whenever you're ready to proceed, Mr. Campbell.
Thank you, Your Honor. Could you please introduce yourself to the jury?
Sergeant Brian Pearson, Leon County Sheriff's Office.
And Detective Pearson, or Sergeant Pearson, how long have you been with the Sheriff's Office?
Since 1995.
What's your current assignment?
I'm the K-9 Unit Supervisor.
And prior to taking that role, what were you doing?
I was assigned as a violent crimes detective.
were you working as a violent crimes detective back in January of 2011?
Yes.
Does the violent crimes unit work as a team?
Yes.
What kind of cases do y'all work?
Anything from sexual batteries, armed robberies, home invasions, homicides.
And did you have an opportunity to respond to Wolf Creek and assist in that investigation?
Yes.
After the crime scene people had documented, did you all start looking for clues or other articles that might give you a lead on who the killer was?
Yes.
And as just as a formality, everything we're talking about, did it happen in Leon County, Florida?
Yes.
Here, let's go back to the second Miranda waiver signed by Trenton Ross. Unlike Trenton Ross's first Miranda waiver dated January 28, 2011, which was witnessed by lead detective Melinda McBride and David Farkas, that yielded no incriminating statements against DeShon from Trenton Ross and no evidence, this Miranda waiver dated February 4, 2011, shows Don Odham as being the only witness, followed by numerous versions of incriminating statements against DeShon Thomas from Trenton Ross, and still no evidence. Don Odham was not the lead detective on the double homicide case. In fact, on or about February 3, 2011, lead detective Melinda McBride and her team of detectives had began to close their investigation of DeShon Thomas and pursue other leads. Also, on February 4, 2011, Leon County Sheriff Larry Campbell announced that he was running for re-election as Leon County Sheriff. The arrest of 17-year-old DeShon Thomas was by any means necessary in order to make Sheriff Larry Campbell, who'd been battling cancer, seem competent and tough to be re-elected as sheriff. Days after Sheriff Larry Campbell announced his plans for re-election, Sheriff Larry Campbell replaced lead detective Melinda McBride with Detective Don Odham on the double murder case of Sterling Connor Jr. and Laqecia Herring. Grand jury indictment charging DeShon with 2 counts of first-degree murder and possession of a firearm by a juvenile delinquent due to the complaint and the summary of offense and probable cause affidavit prepared by and signed by Detective Don Odham during the time when Melinda McBride was the lead detective on the double homicide case. Lead detective Melinda McBride and the majority of her team did not support Detective Don Odham. Again, after lead detective Melinda McBride and others began to close their investigation of DeShon and pursue other leads, that is when Detective Don Odham made arrangements with Trenton Ross to come into the Leon County Sheriff's Office. After DeShon was charged and arrested for the murders, lead detective Melinda McBride reported that Don Odham was being untruthful in his reporting involving Trenton Ross. Immediately after lead detective Melinda McBride reported that Detective Don Odham was being untruthful, on February 17, 2011, lead detective Melinda McBride was replaced by Detective Don Odham. Who is Leon County Sheriff Detective Don Odham? According to an article called Leon County Sheriff's Detective Don Odham, a disgrace to the badge. Don Odham is a wealthy friend of Leon County Sheriff Larry Campbell and Sheriff Campbell's son, State Prosecutor Jack Campbell. Although there were rumors about Leon County Sheriff Detective Don Odham not being an employee with the Leon County Sheriff's Office, it was not until during DeShon's trial as to when DeShon and I learned that all of those sworn reports and sworn court documents and sworn statements identifying Don Odham as a Leon County Sheriff's detective were fraudulent. Don Odham was an imposter. Don Odham had been allowed to impersonate a law enforcement officer by elected officials, Leon County Sheriff Larry Campbell and 2nd Judicial State Attorney Willie Meggs. Don Odham was never an employee with the Leon County Sheriff's Office. During several parts of DeShon's trial, both State Prosecutor Jack Campbell and Assistant Regional Counsel Darren Shippey referred to Don Odham as Detective Odham. And when Don Odham took to the stand to testify, State Prosecutor Jack Campbell presented Don Odham to the jury as a reserve deputy. But even still, being a wealthy businessman who was previously allowed to play roles as detective, crime scene detective, and lead detective in the Leon County Violent Crimes Unit, Don Odham did not testify to being a reserve deputy, but testified to having many years of experience in business and having thousands of volunteer hours with the Leon County Sheriff's Office and having been assigned his own patrol car. Please listen to this audio clip during DeShon's trial of Don Odham's trial testimony on October 16, 2011. Please listen.
Whenever you're ready to proceed, Mr. Campbell.
Good morning. Could you introduce yourself to the jury, please, sir?
Good morning. My name is Don Odham.
Okay. And what do you do for a living now?
I'm a business consultant and a church ministry consultant and also a private investigator.
Okay. What was earlier in life, have you gone, or through your life, have you gone through several forms of business?
Oh, certainly.
Okay. Did you also become a reserve deputy?
I was associated with Leon County Sheriff's Office for a little over 12 years. In the last 2 years of it, I was a homicide detective for them.
As a reserve deputy, did you have to go through the same training as the full-time deputies?
Yes.
Did you go to, before becoming a detective, did they send you to several schools specific for that assignment?
Correct. I went to homicide investigative schools, interrogation schools, and numerous other schools before I was allowed to be a homicide detective.
In your time, are there lots of deputies who work as reserve officers doing various capacities, not being on the full-time payroll?
That's correct.
Full-time, did you get yourself to a position with your day job where you were able to dedicate a lot more hours during the recession to cop work, police work?
Yes, I had sold my business and became I was always volunteering there, had thousands of hours, had a car assigned to me, so I've always worked there for many years. And the last 2 years, after I sold my business, and they'd asked me if I wanted to come and be one of their homicide detectives because I was quite involved with investigative work with them.
And were you working as part of the team working on the investigation of the Wolf Creek murder?
Yes, sir.
Here again, let's go back to the second Miranda waiver signed by Trenton Ross. This Miranda waiver dated February 4, 2011, showing Don Odham as being the only witness, followed by numerous versions of incriminating statements against DeShon Thomas from Trenton Ross, and still no evidence. Don Odham nor Trenton Ross gave sworn depositions in DeShon Thomas's case. Trenton Ross was a 21-year-old fatherless young man facing drug charges when he provided Don Odham with incriminating statements against 17-year-old DeShon Thomas. By the time DeShon went to trial, Trenton Ross had fathered a son and was still facing those same drug charges. Trenton Ross was not facing any charges in relation to the murders. Trenton Ross testified that he was providing his testimony in order to help his pending drug charges. In Trenton Ross's pending case for drugs, the prosecutor and Trenton Ross's attorney were making arrangements to possibly withhold adjudication and give Trenton Ross a break in his drug case. Please listen to this audio clip of Trenton Ross's trial testimony during DeShon's trial. Please listen.
Your girlfriend at the time was Riley Ewell, correct?
Yes, sir.
And you were aware about this very same time that Mr. Thomas and Ms. Ewell, your girlfriend, had engaged in a sexual relationship, right?
Yes, sir.
And you certainly felt that was something that should not have happened between Mr. Thomas and your girlfriend, right?
Sir, like I told them when it was going on, she's a grown woman and he was almost a grown adult. And so, you know, if they felt that was right for them, then they can go ahead and do that. But I mean, I wasn't going to be with her anymore.
Remember when you went to the sheriff's office for your third interview and gave an interview to Detective Odham, Sergeant Gainey? You remember that?
For my third one?
Yes.
I think, sir. I'm not sure. Well, when you talked to them at the time, you felt that it was something that should not have occurred between Mr. Thomas and your girlfriend, Ms. Ewell, right? Yes, sir. I felt that way because of the fact that she was, you know, about 19, 20, and he was 17.
But you weren't happy about the fact that the two of them had gotten together and had sex together, right?
Sir, like I told them, it was their business that what happened.
Well, when you talked to the sheriff's department, as I just suggested to you back with Detective Odham and Sergeant Gainey, when you came down and you talked to them, during that occasion, you weren't happy about the fact that the two of them had gotten together and had sex, right?
Like I said, sir, it's not a point of me being happy.
What I want to know is, isn't that what you told them at that point in time?
What I told them was it wasn't right, sir.
Okay, and you weren't happy about it either, were you?
Asked and answered. Let's move on.
You have pending charges in this case, isn't that correct?
Yes, sir, I do.
In this matter?
Yes, sir.
And although you've said that your case is still, you haven't resolved it, right?
Yes, sir.
Are you aware of discussions that have been taken place between the prosecutor who's assigned to the case, who's not Mr. Campbell, between that person and your lawyer in an effort to resolve your case?
Say that one more time, sir.
I said, are you aware of discussions that have taken place between the prosecutor in your case and your lawyer in that case and how to resolve your case without a trial?
The result without a trial? I'm not sure, sir. I'm not sure what you're asking.
Are you been aware of any plea discussions in your case?
Objection, hearsay.
Overruled.
You can answer.
Can you repeat it one more time?
Are you aware of any plea discussions that are taking place in your case?
What do you mean by the plea discussions? Such as what, sir?
Yep. I'm not asking you for specifics, but do you ever talk with your lawyer about the case?
Which case, sir?
Well, how many cases do you have?
You talking about for the one I have, I guess, my marijuana charges.
Do you have more?
That's the only ones I know of, sir.
That's the one I'm asking you about.
I mean, at the beginning of my case, I did have pleas, but I don't have them now.
But back in September of 2011, there were certainly discussions about your case that apparently involved your input. Do you remember those having taken place?
I'm not sure, sir.
You ever remember somebody offering you a withhold of adjudication, which means you wouldn't have a conviction in your record? Remember that?
No, sir, I don't remember.
You don't remember that?
No, sir.
You ever remember discussion about you receiving a probation sentence, not going to prison?
Yes, sir. I don't remember that stuff.
Don't remember that either?
No,
Okay.
sir.
27-year-old DeJuan Williams did not know DeShon prior to being booked into the Leon County Jail on June 5, 2012. By the time DeJuan Williams was booked into the Leon County Jail, DeShon had been awaiting trial for the murders for over a year. Delays had already been occurring on DeShon's case. DeShon knew that Trenton Ross was not a real threat to DeShon's case because, for one, DeShon knew that he had not murdered Laqecia Herring and her unborn baby, or Sterling Connor Jr. And for two, Trenton Ross had moved out of Tallahassee and had repeatedly made himself unavailable to give a sworn deposition. One of the things that DeJuan Williams and DeShon Thomas may have had in common was that the two of them were wannabe Blood gang members. And I say wannabe Blood is because in the public service announcement regarding DeJuan Williams after having robbed 2 banks, followed by several news articles after DeJuan Williams' arrest, at no time does Tallahassee Police Chief Dennis Jones or Sheriff Larry Campbell refer to DeJuan Williams as a gang member. No one with the Leon County Jail's Gang Task Force Unit was directly involved with the investigation of DeShon soliciting a fellow blood gang member, Williams, to murder Trenton Ross. State Attorney Investigator Jason Newland never states that he informed anyone with the Leon County Jail's Gang Task Force Unit about DeShon's alleged gang activity, which is why State Attorney Investigator Jason Newland relied on DeJuan Williams' interpretation of the gang-coded letter or letters, and which is why State Attorney Investigator Jason Newland teamed up with Deputy Ronald O'Brien to have Deputy Ronald O'Brien smuggle the letter or letters into the Leon County Jail. DeShon Thomas never asked DeJuan Williams to murder Trenton Ross. The audio tapes of DeShon Thomas and DeJuan Williams that were played for the jury has Williams as the aggressor for the need to have Trenton Ross murdered. DeJuan Williams seemed obsessed with the whole scheme. In this email dated March 29, 2012, to me from Gregory Cummings, prior to Gregory Cummings' 2012 firing from DeShon's case, Gregory Cummings states in part, "I have to cancel the depot tomorrow. Paul Strigley, Ross's attorney, got a call Wednesday night that his client did not have money to get here. Paul and I had agreed I would provide him mileage by check, $212.70 at the depot. Then Ross calls Paul. I suggested sending him a bus ticket or paying for one up here to be picked up in Port Orange, where he lives, no go. So final work is Ross cannot make it and we will have to reschedule. Also, it looks like the trial may be reset for August." Trenton Ross repeatedly made himself unavailable to provide a sworn deposition and was not a threat to DeShon's case. Trenton Ross's unavailability was more of a threat to State Prosecutor Jack Campbell and his dad, Leon County Sheriff Larry Campbell's case against DeShon, which is why upon DeJuan Williams being booked into the Leon County Jail on June 5, 2012, given the red carpet treatment to be threatened with the state seeking to enhance Reoffender Penalty Act. Having been introduced to DeShon Thomas and then immediately released from the Leon County Jail with the Leon County Sheriff's Office and the State Attorney's Office providing him with money months after he, Williams, had robbed 2 Tallahassee banks. During DeShon's trial, DeJuan Williams testified that he was providing testimony with hopes of getting a deal on his cases. Walter Cole Rayborn was named in the of offense and probable cause affidavit charging DeShon Thomas with solicitation to commit first-degree murder that was prepared by State Attorney Investigator Jason Newland. In June 2012, it was reported that Walter Cole Rayborn was a trustee within the Leon County Jail and was allowed to move freely between housing units. Again, no one with the Leon County Jail's Gang Task Force provided any documentation in regards to this insider blood gang interactions going on inside the Leon County Jail. Walter Cole Rayborn was in the Leon County Jail for 2 counts of possession of a firearm by a juvenile delinquent. The judge who presided over Walter Cole Rayborn's case imposed jail credit by stipulation, had restitution reduced to a civil judgment, and stated that he, Rayborn, is housed in a facility as close to Leon County as possible that offers VOTEC training. Walter Cole Rayborn's family members who own businesses in Tallahassee are friends with Circuit Judge Jackie Fulford. When Circuit Judge Jackie Fulford began presiding over DeShon's case, the friendship between Circuit Judge Jackie Fulford and Walter Cole Rayborn's family member or members was never disclosed to DeShon. On January 17, 2011, Laqecia Herring celebrated her 20th birthday. Laqecia Herring's pregnancy may have caused her to be a mean ass, but neither Laqecia nor her unborn baby nor her 17-year-old brother Sterling Connor Jr. deserved to be murdered. I don't know what all Laqecia Herring and Sterling Connor Jr. had going on in their young lives, but according to plenty of witnesses who had been interviewed when lead detective Melinda McBride, Detective Don Dennis, Lieutenant Tim Baxter, Deputy Clifton Couch, and others were investigating the double murder, Sterling Connor Jr. had been involved in recent activities that could have caused his murder, and Laqecia Herring had been involved in recent activities that could have caused her and her unborn baby's murder. According to Laqecia and Sterling's family members and friends, Sterling owed $400 to someone and Laqecia owed $350 to Ladidra Jenkins and Ladidra Jenkins' mother. Laqecia and Ladidra argue about the money. Laqecia repeatedly stated that she was not paying Ladidra or Ladidra's mother, Cassandra Walker. Laqecia had planned to move to Jacksonville. In the days leading up to Laqecia and Sterling's murders, Laqecia's best friend, Ladidra Jenkins, posted on Facebook in reference to Laqecia Herring, "I got a hit out for this bitch." The last known outgoing cell phone activity for Laqecia Herring's cell phone was on Wednesday, January 26, 2011 at 10:59 p.m. The following day, on Thursday, January 27, 2011, after 10:20 a.m., Ladidra Jenkins showed up to the crime scene. Ladidra Jenkins stated to Detective Melinda McBride that she went to file her taxes when she saw Facebook postings about losing someone. Ladidra Jenkins was never deposed. Ladidra Jenkins did not have search warrants served on her. Ladidra Jenkins did not have search warrants served on her or her residence or her mother. Ladidra Jenkins was supposed to make a court appearance but did not. In the following audio clip, you will hear Assistant Regional Counsel Darren Shippey admit into evidence a CD recording of Ladidra Jenkins' statement to Leon County Sheriff's detectives versus Ladidra Jenkins appearing in court to answer questions, or Regional Counsel Darren Shippey conducting a formal deposition. After all, it was Assistant Regional Counsel Darren Shippey who filed the motion in limine someone else committed the offense, naming Ladidra as the more likely murderer or having paid someone to commit the murders. Please listen.
So we may have to get another envelope, but Mr. Shippey, you provided me with a DVD for the interview that took place on August 15th of 2013 of Ladidra Jenkins.
That is correct, Your Honor, and that was in support of the hearing that Your Honor conducted on August 19th, 2013. Specifically, the motion at issue was...
What date?
August 19th.
Okay.
And the motion at issue was the motion to argue that somebody else specifically committed these offenses. And the purpose for the DVD was that Ms. Jenkins did not appear in response to a subpoena that had been served on her to attend the hearing. After I had the opportunity to listen to that recording, she answered the questions that I was interested in asking her at the hearing. She had not dealt with those in a prior recorded interview, and that may have been because law enforcement didn't have the information that we had later. So with the state's agreement, I wanted to proffer that in support of the motion. I don't think it would change the court's ruling because she doesn't admit having committed these offenses or having been at the address. She identifies someplace else, but I think it's appropriate for the purpose of making a complete record that what would she have said. I think it would have been very consistent with what she said 4 days before the hearing.
Okay.
I don't know who murdered Laqecia and Sterling, but I do know that my son, DeShon Thomas, did not murder them. And it sickens me to know the extent that grown-ups in positions of authority have overextended themselves to disrupt my family and leave a murderer or murderers in the community. Thank you for watching.
Okay, listen. It's time to cut the crap. I want my son home. Now, it's time for the state of Florida to release my son now. You kidnapped my son. You kidnapped my son, DeShon Thomas, when he was 17 years old. Kidnapping is illegal in the United States. We live in the United States of America. How can we ask other countries to release prisoners when our court system is literally kidnapping our children? I want my son home now. I don't care who has to do what. I want my son now. Because you're not doing him any favors. You're not doing me any favors. You kidnapped my son. And I want him home now. Governor Rick Scott, Pam Bondi, Jack Campbell, Willie Meggs, whoever, My son needs to come home, and he needs to come home now. Because you all are criminals, but yet you have him locked up when you're the criminals. My son was a child. You kidnapped the child. And I want you to release him back into his mother's custody. Because it's been too long. 5 years is too long to be playing games with my family, and no family should have to endure this type of kidnapping through the court system. I want my son, and I want him now.